Like a lapel pin.
What are the major arguments for and against judicial review? Hamilton and Federal 78, appointed life tenure. When you're ready, you may begin.
In Federalist 78, Alexander Hamilton defended judicial review by writing, "A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning." Although the power of judicial review is not explicitly stated in the Constitution, judicial review is apparent in ideals outlined in the Declaration of Independence by checks to the power of the legislative and executive branches. Federalist 78 makes clear the institution of power to interpret law should come from an unbiased and just source accountable to only the Constitution, something imperative to a functioning Republican democracy.
Hamilton was also correct in claiming that judicial review is a key part of maintaining proper checks on the legislative powers, to guard the Constitution and the rights of individuals from effects of those ill humors, where legislative invasions of it have been instigated by the major voice of the community.
Sparked by the Judiciary Act of 1789, Marbury v. Madison left Chief Justice John Marshall to explicitly dictate judicial review by asserting that it is emphatically the province and duty of the Judicial Department to say what the law is. During the case, Marshall declared the Section 13 of the Act of Congress partially unconstitutional. Therefore, Marshall set a precedent of judicial review through rulings of the Supreme Court. Justice Marshall's reasoning is best illustrated in Windsor v. United States, where natural rights guaranteed through the Constitution and the Declaration of Independence are applied to equal marriage rights.
Due to the nature of judicial appointments, life tenure is commonly held as controversial, as Supreme Court justices are not held directly responsible to the public due to lack of election. However, life tenure guarantees Supreme Court justices a sense of job security and freedom of personal expression, independent of public opinion in case decisions. The promise of life tenure during good behavior is founded in the colonists' resent of the British king making judges dependent on his will alone for the tenure of their offices.
In Federalist 78, Alexander Hamilton argues that the standard of good behavior for Supreme Court justices acts as a barrier to the encroachments and oppressions of the representative body. Life tenure creates institutional knowledge as best supported by the dissent of Justice Oliver Wendell Holmes in the 1919 case, Abrams v. United States, in which Holmes expressed an opinion directly contrasting of his previous majority-supported opinion in Schenck v. United States.
Life tenure also grants the Supreme Court the ability to operate independently of public opinion. In the recent Citizens United decision, the public is largely unsupportive of the Supreme Court's ruling. Yet since the Supreme Court was held accountable only to the Constitution and precedents, public opinion in this case did not have an influence to the Supreme Court. Institutional knowledge permits unpolarized decisions, yet partisanship still occurs within the Supreme Court, as executives often appoint justices with similar political leanings.
Justice and executive shared politics is best exemplified in the recent appointment of Justice Sonia Sotomayor by President Obama. Life tenure can incur issues with outdated philosophies and a lack of adaptation to public opinion, yet life tenure possesses benefits in the form of protection from political influence and public interference. Critics of judicial review argue that judicial review is a direct affront to the democratic ideals of the United States government, as the unique election process outlined in Article 3, Section 1 of the Constitution, judges are not elected by the people.
This causes some to fear that the judges lose their sense of responsibility to the people they are charged to protect. Yet the ability for immunity from public opinion supports justices on making decisions based solely on their constitutionality. Best illustrated by Stenberg v. Carhart in 2000, justices' capability of making decisions independent of public opinion strengthens constitutional understanding in the philosophy of higher law. Unlike an elected representative, the only constituent the Supreme Court is held to is the Constitution and past court decisions. Thank you.
402.
I heard a few justifications for having judicial review. The primary one that was repeated was the ability to operate independent of public opinion. My question for you is, maybe they have that ability, but do they? Aren't they still people subject to, I assume, watch the news, read the paper, listen to debates, see riots in the streets? Are they unbiased? Are they free of public opinion?
Well, of course, they're not completely unbiased. I mean, no judge is this perfect epitome of, that citizen that isn't influenced by any media or people rioting, but truly they're not. They have their own political leanings, they have their own interpretations of the Constitution. So they are held to the public opinion in the way where if the public is largely unsupportive of a decision, maybe they can take that into account. But with the recent Citizens United decision, even justices were saying that they didn't personally agree with the decision. As Anthony Kennedy said, it was constitutional, but he didn't personally agree with it.
The notion that they're held unaccountable to public opinion relates more to the fact that they're not elected, so they aren't making decisions based on wanting to get reelected, as some congressmen do. So in that sense, they are independent of public opinion,
Isn't that dangerous?
that they're unelected or,
Yeah, that they're accountable to no one.
well, they're accountable to the Constitution, which is the important thing, that they're accountable to higher law, meaning that nobody, not even the executive or the legislature, is able to supersede the higher law that is the Constitution.
I completely agree with what James just said. The Constitution was written to protect the common good of this country and protect the citizens of this country. Now, that hasn't always been the case, and that's why we have amendments and the Bill of Rights. So the Constitution is even not more influential than public opinion and voting, but it's just as important. And since it's really important that we have a body of government in our system of checks and balances that isn't elected by the people. Therefore, if the people someday decide that they all hate ice cream, it can't just be the justices saying ice cream is terrible. They have to make decisions that are based off of the Constitution and constitutionality, not just what people's whims may be.
Did John Marshall set a dangerous precedent? Because he was one of the first who wrote a majority opinion and penned it in his name. I mean, if we're truly going to have a court of a check, wouldn't it be better to have them write as one, or precarium, versus them writing individual opinions or dissenting opinions or concurrent opinions? You said Anthony Kennedy didn't like the decision but said it was constitutional. Should we know that Anthony Kennedy said that, or should we know that the court itself said that?
I believe it's important that we understand the different viewpoints of each of the judges as they write their dissent or their majority opinion, because that can later be used as precedence to overrule an older ruling, or it can be used to continue that same precedence. And the different reasons that they chose to make that decision should be known, so that the citizens have a better chance of understanding why they did in fact make that decision.
For example, the dissenting opinion in Plessy versus Ferguson had a large influence on the later majority opinion in Brown v. Board. So it's important to have different opinions so that you can see both sides of the argument depending on how a justice interprets the Constitution. Because
But my question is, why should they put their names? Can you have a court dissenting opinion and you don't know who's on what side?
Well, if they're speaking for the entire court, it would be off of the majority opinion, because that's what the ruling is.
But what I'm saying, so let's say we have a 5-4 decision, but we don't know who the 5 and the 4 are. There's a majority opinion and there's the dissenting opinion, but we don't know what justices wrote which. Wouldn't that really provide a court as, instead of, is it dangerous that they're unchecked? He asked, is it dangerous that there's no way to hold them accountable? Well, now we don't know who wrote what. Does that provide them with more freedom or independence to truly write what the law should be or how it should be interpreted without worried about even a slight bit of public opinion?
In some ways, it can add more independence and freedom. For example, with the Federalist and Anti-Federalist papers, they didn't write John, this is written by John Adams. Instead, they used pen names. So pen names can be helpful in the sense that people are taking the opinions not for who was writing them, but what they actually say. But in some ways, it is important that we know who is writing these opinions, as there is no one perfect way to interpret the Constitution. If we can look at, Justice Ginsburg wrote this on this opinion, maybe I can look at her writings, maybe I can look at what she's thinking, so I get the whole picture of why that justice was interpreting the Constitution the way they were.
Also, occasionally, having public influence on Supreme Court justices can benefit their institutional knowledge. For example, with Justice Holmes in Schenck v. United States, after Abrams, a Harvard law professor wrote him and detailed, very explicitly stated why his majority decision was incorrect and why Abrams was stating was not anything other than him adding to a marketplace of ideas. And he uses that knowledge that he gained because people saw that he was the one who wrote that decision in making his dissent in the next case, stating that there was no reason why Schenck was, what he was saying was unconstitutional.
Know that better.
Yes.
We'll stop there. Know that it's Schenck that he writes Clear and Present Danger. It's Schenck in which the Harvard law professor belittles him, and it's in Abrams in which he writes the dissenting opinion. Schenck's first, Abrams the second. Know that better.
Shank someone and then Abrams.
Rich, go ahead.
Good. I'd like to see both in your direct examination, or excuse me, your direct testimony, a little more feeling, a little more, emphasis, and just a little more delivery to really drive it home, so it's not just a boom, 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 recitation of facts, get on, so that then you can steal up and prepare for cross. On cross, I think you all did a good job. I'd like to see a few more examples, a few more sort of definitive stands and definitive arguments. There was a lot of kind of like equivocation, for instance, in that, I think Mr. Clark's argument was an interesting one in terms of, should we even have justices applying their names to opinions? Kind of sort of argued, oh, well, it works pretty well on the Federalist Papers, but now there's, it's fine to have a pro and a con, but I'd like you to take a position and be a little more firm on it. And certainly if you're going to be citing to any cases, if you're going to be citing to anything, know it well. Know it so that then we have faith in not just that answer, but all the other answers you give. So I think overall in terms of high points, good stuff, good delivery, good breadth of the subject, but it'd be nice if you guys could go a little deeper on some of these examples and state your case with a little more conviction. Good job.
Okay, I liked when they were asking about the value of the opinions, and you brought up the dissenting opinions. A lot of times we forget that piece of it, that even when you have a definitive ruling from the Supreme Court, lawyers still take the dissent and use it in arguments. And they still take dicta, so not just the substantive argument, but they take things that are said and they use it. So everything that is published by the Supreme Court, we are using them one way or another in our justice system, no matter where they go with it. So I really like that you brought that in. I think that was really important. There was something that tripped me up in the direct, I think it was on your part, you mentioned something about Citizens United and being constitutional. And I understand later from your further explanation that what you were trying to say was some of them didn't necessarily agree with it, but they felt like they were following the Constitution. But something about it tripped me up for a second, because there's a whole lot of people that still feel that it wasn't a constitutionally valid holding, and you may get a judge who has that, and they may get distracted by that. So I'm not sure exactly how you stated it.
It was in cross.
Was it in cross? Okay, there was somewhere it came up about the Citizens United, and I thought, anyway, it sort of distracted me for a minute. So, but what later when you talked about it, you said something about it being that they were just sticking with their constitutional interpretation.
Yeah.
So if you stick with saying it that way, no one's going to get tripped up on what you're saying. But if you're trying to say they just did it because it was constitutional, then you may get someone who gets distracted by that because they may disagree. Your judge may totally disagree on that one. But this was I think the 14th Amendment's a tough
one to know and argue. I think you did a good job considering how incredibly difficult this is, and I think you guys are getting there with it. Good job. Nice work.
On your testimony, what was your time?
402.
For the most part, good presentation. We need to work on presenting and not reading. Annie, you gotta slow down because you went to one part and then transitioned to another, and I can't remember what it was, but I'm like waiting for the end of this one, and you went into a whole different subject, and there was no gap to bridge the two. So you got to make sure that you're emphasizing those points, and I was trying to hold it up for you because you were doing that. You were going so fast that that part was missing. I think that was part of it. So you just got to make sure use who you are, your personality, to get those different parts that you're trying to present accurately. I like how you guys do go Annie then James because you're so passionate, and then James is kind of this slow, methodical. I still want to listen to, and you guys balance each other real well in terms of going back to back.
Yeah.
Really good start. I think I love the way that you start, and you follow her very well. All right, but just stop reading.
Yeah, I forgot we changed this quote last week, so I had like the other quote like kind of ready, and I started like.
Excuses.
But yeah.
If you're gonna use Federalist and Anti-Federalist for pseudonyms, don't use John Adams because he wasn't part of any of that debate.
Oh, I was gonna say some John, but it just came out.
James.
James, yeah.
There's one sitting next to you. You can use him, but Madison or Alex.
James Osgood.
It would be John Jay.
Federalist Papers.
It would John Jay, or you could use any of the Anti-Federalists. Lesson 25 would be the applicable book. I forget exactly what page, has a very good description of the interpretations of the Constitution. Textualism, originalism.
Page 180.
Is it 180? Modernism and fundamentalism. Okay.
We've heard that like 2 processes ago.
We got it because you kept on talking about their interpretations. Well, or interpretations such as originalism does this, and there's an answer that now their interpretation now has meaning to it, and then you can attach that to Clarence Thomas, or the textualism, Antonin Scalia, or the modernism, Anthony Kennedy, playing into those roles. That's how you could talk about Citizens United. He has a modern approach where he doesn't like what the decision does, but he still believes that it has brought the Constitution forward by still keeping the words of the Constitution. Do you guys know what an amicus brief is? An amicus brief is a brief from a friend. It's Latin. It's called an amicus curiae brief. And in appeals cases, it is a brief written by a party that is not directly in the case. So for an example, the case Schneider versus Phelps is a father of a fallen soldier who is suing the head of the Westboro Baptist Church for protesting his son's funeral. An amicus brief filed on behalf of Westboro, NPR, New York Times, Associated Press, who else? First Amendment Coalition, CBS News, ABC News, CNN, Fox News, all these networks, all of these broadcast media wrote a brief in favor of Westboro. Were they in favor of what Westboro's doing?
No.
Right?
Hopefully not. I don't know.
Exactly. But they're writing that if the Supreme Court limits what Westboro does, they are also limiting what they can do. Is that public opinion? Absolutely, it's public opinion. It is a process through which the Supreme Court makes decisions, is that they allow these briefs to come through to see the viewpoint of this case beyond just the case itself. And that's very much public opinion. The 2 lawyers for the 2 opposing sides get to decide which amicus briefs are filed so that they agree, so that they have equal playing field on that, so it's not just random amicus briefs left and right, but those definitely play a role in the judges, so something to use.
Okay.
That's all I got.
Cool.
Keep going, good job.
Thank you.
Get out of here, eat some more pizza.
What question was that?
3.
The only reason I knew the page was they told us that in our last room.
I've been studying a quote from Justice Holmes' dissent about when someone, I'm pretty sure it was a Harvard professor.
What's his name?
I can't remember.
Orange. Oh,
Made a reference to